So as we said, punishments according to their independency are of three main categories. Number one, the original or the main punishment. Number two, the supplementary. Also it is named as complementary punishments. And then finally, in number three, the accessory punishments. And we will now move to every kind of these punishments and to illustrate each one in details, inshallah. Number one, the original punishment or the main punishment of the crime. Actually, the original punishment is the main punishment that is designated by the legislator for those who commit the crime. For example, when we say that everyone who commits murder shall be liable to capital punishment. According to this text, for example, the capital punishment is called the original punishment, since the legislature in this case designated the capital punishment as the original and the main punishment for those who commit the crime of murder. So we called it the original punishment. So the original punishment is the punishment that is designated mainly for those who commit a specific kind of crimes. So this is number one. Number two, the original punishment is sufficient per se to achieve the intended pain as one of the punishment's features. We discussed previously the characteristics of the punishment. We've mentioned that the punishment shall be a judicial one. The punishment is a legal one, which means that no crimen sine lege and no pena sine lege. And number three, that the punishment is a painful one. So what makes this punishment painful? The size of the rehabilitation that it has, the size of or the magnitude of the pain that it has. So it is when the punishment is sufficient to achieve the pain as one of the main characteristics of the punishment, then in this case we call this kind of punishments the original one. So the original punishments, like the capital punishment, it is the most painful punishment. When we say the lifetime sentence or the lifelong imprisonment, it is original punishment, since it's sufficient in itself, in per se, to achieve the main goal of this punishment and the main pain of this punishment. Number three, the original punishment means that the sentence that is made by the judge shall include this punishment. So the judge shall name it and shall decide this kind of punishments in an accurate way. So if the judge gives someone the liability to imprisonment, he shall give him a certain number of years. For example, he is liable to 7 years, he is liable to 3 years in imprisonment. So he has in this case to name what is the punishment, imprisonment for example, and to name what is the number of the years or the months that this person shall spend in the jail. So this is number three regarding the original punishment. So it's a main punishment. It is sufficient per se to achieve the intended pain, and the sentence made by the judge shall include this kind of punishments. And finally, it can be the only punishment for the crime, like what we mentioned. Everyone who commits a murder shall be liable to capital punishment. So this is the only punishment, the capital punishment. It's one, and actually it's one, and there is no kind of punishment that is added to this main punishment. So this is original punishment, this is main punishment. Okay, examples for these original punishments that may be alone, that may be decided alone without any kind of punishment added to them: capital punishment, lifetime sentence, hard labor, or even fine. And this actually in cases of the contraventions regarding the violation made to traffic lines and something like that. These are examples. for a main punishments or original punishments, like in this case is guilty of a felony and liable to imprisonment for 7 years. So the judge shall say this person is convicted with for example inducing someone to commit a crime. He is liable to imprisonment, and he's liable for 7 years of imprisonment. In this case is guilty of a felony, and he has to say that this person shall be put in imprisonment and for 7 years. Like in the arson crime, when the person is committed arson, then he is guilty of a felony. So as a judge I shall say that this person is guilty of felony and he is liable for imprisonment. So I named the punishment, and for 14 years for example, and I named the numbers. So in this case the imprisonment in this case is a main punishment. It is alone in this case, it's a main punishment, and it is called original punishment. Number 2, the accessory punishments. Accessory punishments are punishments that are applied ex lege. Ex lege means that they will be applied without the need that the judge shall name them. So even if the judge did not name such accessory punishment, they will be applied, since the law gives these punishments for the person who commits such crimes. Like when someone kills another person with a dagger, then this is, in this case, the dagger or the knife or the pistol shall be confiscated, even if the judge did not give the wording in his verdict that this person shall be put in jail and the tool of the crime shall be confiscated. If I am a judge and I told and I gave my punishment and I gave my judgment, and I told and I said that the person must be put in jail or must be liable for capital punishment, but I did not mention the tool of the crime, it doesn't mean that this tool mustn't be confiscated since the punishment is not named. This is simply because the confiscation shall be done in this case ex lege, I mean without being named by the judge. Number 2, the accessory punishment is not sufficient to achieve the intended pain. So the fine sometimes is not sufficient. The confiscation sometimes is not sufficient to forbid someone or to prevent someone from ordinary merits is not sufficient in per se or in itself to achieve the intended pain. So these kinds of accessory punishments are not sufficient to achieve the intended pain. And the sentence may not include the punishment. It means that the judge cannot can give his sentence without naming such accessory punishments. And this is the number 3. It fits with the reality of number 1, or the fact that is mentioned in number 1. Number 4, the judge has no discretion regarding this kind of punishments, to postpone them, to suspend them, or even to grant probation or suspension regarding them. So if if a person kills another person, then in this case, if I found him guilty as a judge, then in this case I cannot say that he must be found liable to capital punishment, but the tool mustn't be confiscated. He cannot do so. I mean, the judge cannot do so to postpone or even to suspend the confiscation in this case. It accompanies with original punishments. So we cannot find a judgment that contains only accessory punishment. The accessory punishment is always added to the original punishment. The examples for such kind of accessory punishments: the confiscation of properties, loss of electoral rights, removal of honorary titles, loss of parental rights, prohibition of carrying out specific activities, and prohibition of driving. And this is in